Please rise. Justices of the Appellate Division, Supreme Court, First Department. Hear ye, hear ye. All persons having business with the Appellate Division, draw near with your attendants, and you shall be heard. Please be seated.
Good afternoon. Welcome to the Appellate Division, First Department. As I call the calendar today, please ask for the time that you actually need. And remember, if the panel has additional questions beyond the time you've been allotted, we'll ask them and you'll have a chance to answer. You've read your papers and are familiar with the issues that underlie your appeals. For those of you here for the first time, you should know that the white light in the lectern will go off when you have 2 minutes left, or if you've asked for less than 2 minutes, it'll go on immediately. When I call your case, rise and let me know who you represent and how much time you are requesting. People v. Tory Gibbs. Admitted. Smartmatic USA versus Fox Corporation. Granted. 6 and 2 and 6. Thank you. Richard v. Walls is 2 appeals. Richard v. Walls. Appears you have no opponent. You want to talk to us? I'll give you 3 minutes if you like. If the court has any questions, I'm happy to answer them. If not, I'm happy to submit. We'll take it on submission, I believe. Thank you, counsel. Counsel, you're sure your opponent is not here, right? I have not heard from my client. Usually they have to stand up when I ask them to, so. All right, thank you. So we will not, that will be taken on submission. Thank you. Geiger versus Hudson Excess Insurance. Okay, I'll give the cross appellants 5 and 2 and 5 and 2 and 5 for Hudson. 3604 Jerome versus NYC Health and Hospitals. Counsel. I think we'll take it on submission, counsel. Thank you. Brown versus Gutierrez. Doctor, the other side's not here, but if you like, you can address us directly, but I'll give you 3 minutes for that. Brito versus, People v. Taquayon Anderson is on submission. Brito versus City of New York.
New York City Housing Authority, defendant respondent, 6 minutes.
Universal Construction, party defendant respondent, 3 minutes. I'll give you 5 and 2, 4 and 3. Mama versus New York City Department of Education.
For the appellant, 5 and 2, please.
5 and 2 and 5. Stromberg versus East River Housing.
The appellant, East River Housing, 6 and 2, please. 6 minutes for response.
I'll give you 5 and 2 and 5. Pickin v. RN Realty.
Robert Tolchin for the appellant, 7 and 2. Daniel Hoffman for the respondent, 5 minutes.
5 and 2 and 5. Melling v. Corinthian Condominium.
Good afternoon, Your Honor. Gary Strong on behalf of appellant Condominium. I do not believe my adversary submitted anything or is arguing that I would be happy to take on submission unless you have questions for me.
We'll take it on submission, counsel. Thank you. 99 Wall versus Concealy and Associates. How much time do you want for 99 Wall? Okay. Yep. You have a cross appeal, right? Do you have a cross appeal? You're for Concealy, right? I'm sorry. Okay. 5 and 2 and 5 and 2. Thank you. Kshatriya versus Office of Chief Medical Examiner. 5 and 2 and 5. People versus Anand Mahabir. Submitted. Franco versus 800 East 173rd Street is submitted. Okay. First case up is Smartmatic USA versus Fox Corporation. Please.
May it please the court, Wynn Allen, Kirkland & Ellis for appellant. In this appeal, Fox is seeking to compel the production of a narrow, targeted set of documents, namely documents showing how Smartmatic's customers and business prospects have been impacted by the indictment of 3 Smartmatic executives for bribery.
You're not even seeking the total sum of documents that were given to you by the JHO, right?
We're not, Your Honor. We've narrowed our appeal to the most relevant category of documents, which are those documents that show how Smartmatic's customers have reacted to the indictment, which we believe is most relevant to Smartmatic's special damages claim, in which they're seeking over $1 billion in lost profit damages for business they purportedly will lose between the date of the indictment and 2035. They bear the burden of establishing causation for that lost profit argument, and we're defending by saying there are alternative non-Fox causes to these damages. One such alternative cause is that customers in the future may very likely be very hesitant to do business with Smartmatic because 3 of its executives were indicted. And that discovery is particularly important because when asked about those issues in depositions, Smartmatic's witnesses invoked the Fifth Amendment nearly 250 times, and its president and co-founder, one of the indicted individuals, invoked the Fifth Amendment over 100 times. So this information, Your Honor, that we're asking, it's narrow, it's targeted, and it's directly relevant to alternative causation evidence, which goes to our defense for their special damages claims, again, which exceed $1 billion for between the indictment and 2035. We believe the motion court erred in denying that discovery for 2 fundamental reasons. With respect, I have a great deal of respect for the trial court judge in this case. I've been before him many times, but I do believe he got this one wrong. First of all, the motion court applied standards of admissibility rather than standards of discoverability. And you can see that because the motion court relied on People versus Formosa and People versus Miller, which are admissibility cases, not discoverability cases. The motion court also applied what it said was a presumption against admissibility that doesn't exist when you're seeking to use this evidence for this purpose. At best, such a presumption applies to prior bad act evidence that's used for impeachment purposes or as propensity evidence.
So, counsel, let me just make 2 things clear. You're not seeking any waiver of any privileges. So you're seeking non-privileged documents, correct?
That's correct.
And you're also only seeking documents concerning the indictments to the extent that they connect to lost profits or future business, right?
That's correct,
Not
Your
just
Honor.
any document about the indictment, but only to the extent that they connect to the damages claim in this case.
That's absolutely right, Your Honor. That is the information we're seeking, and that's the evidence that we believe is relevant to our defense to Smartmatic's special damages claim, and particularly the causation element of that claim, Your Honor. And again, you know, when Smartmatic itself has put this at issue, when it filed this case in 2020, it knew it was under investigation in the Philippines. When it sought damages running to 2035, when it sought special damages running to 2035, it put at issue it itself assumed the burden of having to prove a causal connection between those damages and the alleged defamation that occurred at the end of 2020. We're entitled to defend against that by pointing to alternative causation evidence, and there could be many such reasons for alternative causation. There can be poor products or uncompetitive pricing or subpar service, but another such cause might be customers being hesitant to do business with Smartmatic because its president and co-founder has been indicted for bribery, and we're at least entitled to explore that in discovery. We can deal with admissibility down the road, we can deal with possible limiting instructions down the road, but at least
I suppose there might be a disposition that's favorable to them in the Florida prosecution anyway.
there could be, Your Honor. That case is set to go to trial this fall. It's possible that there's a favorable disposition in that case. It's favorable, there's not, but we won't know that until the fall, and we certainly don't know how customers are reacting to this news.
But whether or not it's favorable, that's really not relevant to the documents you're seeking. It's the effect that the existence of the indictment and the charges has on the customers at this time and possibly in the future.
That's absolutely correct, Your Honor. Again, we're not, whether these claims are ultimately proven or not is not frankly relevant. It's the impact it's having on Smartmatic's ability to win business into the future, the impact it's having on Smartmatic's actual and potential customers, and the impact it's having on how the company is evaluating its go-forward profit expectations.
And this is all for your defense as to the issue of damages in this case.
That's correct, Your
Which are quite significant, quite a significant amount of damages sought by the plaintiff.
That's correct, Your Honor. Just for the period after the indictment, from the indictment to 2035, by our calculations, they're seeking around $1 billion in special damages just for that period. They're seeking more for other periods as well. Unless the court has other questions, I'll save the rest of my time for rebuttal.
Thank you, counsel.
Good afternoon, and may it please the court. Jamie Ward for Smartmatic Plaintiffs Respondents. Now, as the panel has recognized, the discovery sought by Fox before the motion court was significantly more expansive than the discovery that's sought in its instant appeal. And to justify this incredible scope of discovery before the motion court, Fox told the motion court that it intended to utilize this discovery for numerous purposes: to attack the credibility of Smartmatic's witnesses, to, quote, expose Smartmatic's...
You make that point well in your brief, that you think that they're trying to make the jury distrust Smartmatic, but really what we're talking about here is discovery, not the jury at this point. We're just talking about what might lead to admissible evidence, not what is admissible.
That's correct, Your Honor, but I think the statements made by Fox before the motion court are important to contextualize both the request they made below and the purpose that they intend to use this evidence.
But let's deal with what they're seeking on appeal, which is what's in front of us, which are documents from Smartmatic that reflect customer opinions or statements or willingness to deal with the company after the indictment. And there's no dispute that those documents are relevant to your damages claim.
To the extent that there is a document, an example of communication from a customer or potential customer that is on Smartmatic's special damages claims that happened after the indictment and the customer is inquiring or expressing concerns about the indictment, I agree with you 100%, Your Honor.
So there it is. That's what they're seeking on appeal. So it seems like we're sort of in agreement that that the documents they are seeking on appeal, which are documents that you may have concerning your customers or your business that go to your damages claim of lost profits, those documents are relevant. I confirm with counsel that Fox doesn't seek privileged documents, so I don't know what the dispute is anymore.
So I think the issue is, Your Honor, is that Justice Cohen's order does not need to be vacated in order for this to be effectuated. Before the motion court, Smartmatic notified the court that it had already produced such documents, and in fact, documents like that are cited in Fox's own briefing. And again, Justice Cohen inquired.
Well, that Justice Cohen's decision precludes those documents, right?
In our view, it doesn't, Your Honor, because as I mentioned, we have produced that documents and we represented to the court that we understood that we had an ongoing duty to supplement. So like I told Your Honor, if a document comes into existence where a customer that is part of Smartmatic's special damages claims expresses concern about the indictment, we will produce it to Fox. And that representation was made before the motion court.
So if I understand you correctly, your argument is that in light of the limited degree of discovery your friend is seeking now, and what you have already turned over, this appeal is moot, save for your continuing ongoing obligation to produce?
I believe this appeal is moot, Your Honor. Justice Cohen was aware and that Smartmatic recognized that it had an ongoing duty to supplement its discovery. Accordingly, his order dealt with the broad swath of the rest of the discovery Fox was seeking and didn't need to explicitly call out this area, which Smartmatic had already represented that it understood it had a continuing obligation to produce. So simply speaking, there's no need to vacate Justice Cohen's order in order to effectuate the discovery that Fox.
What is it about Justice Cohen's order that you think is still relevant?
As Fox has recognized that it is not seeking to appeal the vast majority. So as to anything but the very narrow categories that it's presented before Your Honor, Justice Cohen's order is still in place. But again, with regard to this category regarding customer inquiries, which Smartmatic represented to Justice Cohen that it had produced similar documents relating to the investigation and understood it had a continuing obligation to produce with regard to the indictment, there's no need to vacate that order because Justice Cohen's order does not preclude that production.
The off chance your friend is going to disagree with you regarding the level of production, could you marshal for us what it is that's been produced that would moot this appeal out?
Of course. So to give a little context as far as the time frame, document production wrapped up in this case in July of last year. Discovery was set to close mere days before the unfortunate passing of Mr. Dobbs, the defendant, and the case was stayed for some time before it was reactivated. Up to that time, Smartmatic had produced and had done an active search for. This is not just incidental production. Had produced, questions, concerns, comments from its clients regarding the investigation, and Fox cites to a number of those in its brief. Now, document production had closed at that point, but in response to Justice Cohen's questioning, we agreed and represented that we understood we had a continuing obligation to supplement.
But continuing obligation can mean many things. It means that you have to continue looking for documents, or it could mean that you have to go into 2021, 2022, 2023, 2025, up until the date of trial. So let me ask you, when you say we recognize we have a continuing obligation, what do you mean by that?
So, Your Honor, as far as I understand Fox's request here, they are only seeking such documents to the extent they post-date the indictment, which was August of 2024. And so we understand and have recently conducted a search for any such documents from August 2024 to present. And
I'm going to ask because that wasn't my understanding. Maybe that's what they're seeking, but I thought that they were seeking more than that. So we'll find out.
Thank you, Your Honor.
Thank you, counsel.
Let me start with 2 points. First of all, we haven't received a single document from Smartmatic that post-date the date of the indictment. The indictment was from August of 2024. We haven't received a single document.
Were you limiting your request for documents just after the indictment, or was it when there were claims that people knew about and were discussing things allegedly before that?
It's pre and post indictment. They need to conduct a robust search for these materials pre-indictment. I was just making the more fundamental.
Starting when?
Starting when the investigation became public in the fall of 2022.
When the investigation became public
In the fall of 2022.
Right, okay.
Correct. But they also haven't produced a single document from after the date of the indictment. To my knowledge, and maybe they know things I don't, they haven't gone back and collected documents from Smartmatic employees and searched them for customer inquiries after August of 2024 and determined, are there customer concerns being expressed? How have the company's financial projections changed? To my knowledge, they have not gone back and reconducted those searches, reviewed those documents, and then produced anything that's relevant to us. So we have two requests. One is, prior to the indictment, they go back and conduct an appropriate search for these documents and produce them to us. And then for post-indictment until today, they go collect the appropriate search of those documents, run their search terms, review those documents, and produce relevant documents to us. Again, that just pertain to customer reactions and financial projections about how the indictment is impacting their business.
So
What about counsel's comment during her argument that there is no reason to vacate Judge Cohen's decision because it just relates to this one issue.
Respectfully, I think that the order does need to be vacated because they've argued to us before that that order precludes this discovery. So this is the first time I've heard that they have some reading of it that it might not. And Justice Cohen his ruling, at least under my interpretation, seemed to be that under cases like Miller and Formosa, we weren't allowed to get these materials. So I do think the order needs to be vacated so it's very clear that these are discoverable.
Other questions? Thank you, counsel. Thank you both.
Thank you.
Next case is Geiger v. Hudson Excess Insurance.
Good afternoon. May it please the court. John Goloszewski on behalf of the appellants. The case concerns two separate policies. I'd like to start with the Lancer policy. Coverage under this policy is going to turn on the interpretation of the term legally obligated to pay. Importantly, Lancer decided not to define that term in its insurance contract. It decided not to define the term loss. And if you look at the Eastern District of New York's decision in the Intelligent Digital case, citing reams of authority from within and without New York, the exact situation that we're dealing with here, quote, an insurance company remains legally obligated to pay a claim under a policy even where the claim was assigned to a third party and the third party agreed not to execute a judgment against the insured. That is the exact situation we have here. Vola agreed to the consent judgment, agreed it was legally obligated to pay that judgment. Thereafter, an assignment was entered into in consideration for a covenant not to execute that judgment vis-a-vis Vola. This happens all the time in the context of bad faith insurance denials. The McDonough case cited by the trial court does not apply here because what the McDonough case held was, quote, a release discharging an insured from all liability. All liability.
Well, what liability did you retain?
Did Vola retain?
No, yeah, Vola.
Vola.
What liability did you retain
Vola had
from
to consent to a judgment of $200,000 against it. That Vola.
But with the release, what liability what possible claim against you is still remaining?
Against.
Yeah, Vola.
Against
right?
Vola.
So in other words, if you release Vola from everything, the McDonough stands for the proposition, I believe, a fortiori, you release the insurer.
Yeah, but Vola wasn't released from all liability. Vola had to.
Did you sign a release?
There was a settlement agreement.
And in there, is there a release?
There is a release language which specifically does not include the obligations under that settlement agreement.
I don't understand how that could be. Your insurance company is not liable for your settlement agreement unless it agrees to it, right? Under your policy.
The question is whether is there legally.
I'm asking you
Yes.
the question, so I'd
Sure.
like you to answer that question.
Sure.
Right? Could your insurance company be liable for the settlement agreement without its agreement to be liable for it?
Sure.
Could you settle the case without your insurance company?
Vola settled the case after the insurance company was put on notice and denied. Of course, they were on notice of this.
So how could it be that you could release yourself, but not you could release Vola, but not the insurance company?
Because the insurance company wasn't a party to the consent judgment. It wasn't a party to the settlement agreement. The covenant not to execute specifically only took effect after the assignment was in place. I'd like to very briefly touch on the Hudson because I see that.
Yeah, talk about they make the point about your applications, that they were not forthcoming, and therefore the
Sure.
policy is void ab initio.
Sure, Hudson's entire rescission argument is based on a fabricated statement by their underwriter that says, quote, Vola operated a late-night adult entertainment lounge and strip club with exotic dancers. This is categorically false. It is absolutely.
He said some other true things, though, about Mr. Ciccone we're talking about?
Yes, correct.
Yeah, he said you guys represented that you did not have hookahs in the bar.
Well,
I don't know how material hookahs are, but
nor do I, but when we're talking about rescission of a contract, the burden is on them. Materiality must be clear and uncontradicted. They could have submitted an affidavit that said, the issue of hookah is what this turns on. They didn't do that. What they did is one repeated false statement after another that Vola was operating a strip club.
What is the appropriate standard in gauging materiality? What is the
Rescission
legal?
of summary judgment is only appropriate where materiality is clear and uncontradicted.
What is materiality?
Materiality is the underwriter stating, but for this representation.
Is it that strong of a test, but for?
I believe so, Your Honor, especially at summary judgment, especially when we're talking about rescission of an insurance company. Absolutely. It is. That's our understanding of it.
So let me ask you, you stated that the restaurant closed at 9 o'clock. Was that's?
It didn't. There was a check mark next to
Right,
last
but then,
call,
look, I
1
looked at it.
o'clock.
Let's assume that I think that your application says we close at 9 o'clock. We don't have a dance floor. We don't serve alcohol. All of those, after that period of time, all of those representations were false, correct?
No, because
Are you denying that, let's start with, are you denying that you served food and beverages after 9 o'clock?
I believe that's accurate.
You did or did not?
They did, but
Right,
that
okay,
doesn't
and on your,
contradict.
one second,
please.
counsel, on your application, you said, we do not serve after 9 o'clock, right?
It doesn't say that, Your
Or
Honor.
11, maybe it was 11
There was a
o'clock.
check mark next to last call is at 1 a.m.
Okay, do you agree that, all right, how about having a dance floor? You said you don't have a dance floor.
There's no evidence that there was a dance floor. They have no evidence that there was a dance floor at that restaurant and bar.
How about the advertisement you sent out to the community about?
There's no prohibition against DJs either. There can be a DJ without a dance floor. They had ample time and discovery to get all of this information.
Okay.
They could have subpoenaed the Vola principal and found out exactly what sort of operation they were doing. They chose not to do any of this.
Okay.
And if we're looking at the affidavit of the underwriter that is rife with misrepresentations, and based on hearsay, he has no firsthand knowledge of the operations of the club, as evident by the fact that he continues to
Counsel, you make
misrepresent
that
it.
point in your brief. Thank you. You have time in rebuttal.
May it please the court, Brendan Fitzpatrick, counsel for the respondent appellant, Lancer Insurance. Your Honors, there was the release. There was not only a release in this, there was a denial of liability. There was an acceptance as true and accurate of denial of liability by plaintiffs. They drafted this agreement, the settlement agreement. Lancer had nothing to do with it. They could have easily carved out an exception where Vola agreed to some liability. They could have consented to some liability. Simply saying we're going to pay this consent judgment as a business decision because you've promised that you will never go after us. That's impactful.
Isn't that the linchpin to say that you will not go after us anymore,
Yes.
right? And that's the release, and
no-
that's what those cases,
The no recourse, Your Honor.
right,
There's
no
a judgment
recourse.
entered for 200K, but we're not going to go after you.
Yes, and that it's specific.
Vola. Yeah.
And so what is the legal principle or doctrine that prohibits them, or appellate authority that prohibits them from charting this sort of course?
I believe McDonough definitely supports it. The agreements and the releases, as well as the agreement within McDonough where it says we will never go after Dryden for anything, even if we are not successful. It's all on the underlying plaintiffs. Same thing here. That's the authority for it, as well as the fact that, again, it's a matter of drafting. They could have easily put language in there.
And McDonough says specifically that the settlement agreement explicitly provided that the
Underlying.
Vola party would have no future recourse, the plaintiffs in the other lawsuit, against the claimant in the underlying action, regardless of whether any recovery is obtained from the insurance company. And the court said that release effectively released the insurance company,
Because then there
correct?
would be, in the
Right.
cool words of the trial court, in this case, there would be no underlying advertising injury that would ever trigger
Right.
Lancer's indemnification obligation. And that's what we have here. And if, Your Honor, if I could just follow up with what the court continued, the third department in McDonough said, because of the language of the settlement agreement and releases relieved the plaintiffs of legal liability. The insurer's duty to indemnify was also therefore extinguished. And that's exactly the situation we have.
Right,
That
because-
doesn't make you an insurer, it makes you a guarantor.
Yes, and again, regardless of, the denials, the acceptances of the denial, we'd be on the hook. Every insurance carrier would be on the hook for everything.
And your argument is because because the VOLA is no longer obligated to pay, and that was what the relief says, I am not obligated to pay this settlement amount, then the insurer also is not obligated to pay.
Precisely, Your Honor.
And that, I think,
We made several other arguments there contained in our brief. I would not, I think they've been fully briefed unless the
Right.
court has any further questions. Thank you.
You also have time in rebuttal, counsel.
Pardon?
You have time
Yes.
in rebuttal as well.
Good afternoon, may it please the court. Stephen LaBelle on behalf of Hudson Excess. I wanted to just first briefly touch on Your Honor's question earlier about what is the standard for material misrepresentation. I don't believe the court got an answer to that, and I'm citing to the Arch Specialty case, which is a First Department case. The standard is that misrepresentations or materials a matter of law where the insurer demonstrates through documentation such as in-force guidelines that the insurer would not have issued the same policy had correct information been disclosed.
Did you make a prima facie showing in that, under the Arch Specialty standard?
Yes, Your Honor. It's the position of Hudson Excess based upon the guidelines, Mr. Ciccone's affidavit, that on his knowledge of Hudson's practices, as well as the
You want to
applicant.
just address briefly whether Ciccone had enough personal knowledge to make that affidavit?
Yes, Judge, Mr. Ciccone actually relied upon the documentation that the plaintiff relied upon in obtaining the consent judgment and was attached to the complaint, which includes the photographs that, under the case law, constitutes binding admission and admissible
so,
evidence.
yeah, let me ask you, what did the insured represent on its insurance application that you are saying is a material misrepresentation?
Yes.
Because counsel's saying, we didn't represent, we had a disco or whatever, a dance floor.
Sure. There are no less than 11 misrepresentations.
Well, pick the biggest ones.
Sure. I will do that right now. Operating hours, 12 noon to 9 p.m. It's clearly false based upon the advertisements. Open till 4 a.m. in the morning, drinks all night. So that's false. Number two, any entertainment provided, answer no. That's false.
And a DJ, obviously,
was-
in common
right. And it says
parlance, is entertainment.
Correct, and it also says live dancing in more than one of the images that were attached to the plaintiff's complaint. And I would also add that because this was, at least it's Hudson's position, a new argument that was raised, those photographs where counsel is trying to disavow them to third parties, I'm sure the court has reviewed them and they're in the record at 66 to 80. They say on top of them, sorry, the name of the insured is Sorry Not Sorry. It says Sorry Not Sorry Presents. It also has an email address for Sorry Not Sorry, a hashtag for Sorry Not Sorry. So you can't pawn this off on third parties when Sorry Not Sorry is the entity that's indicating that they're the ones that are presenting this entertainment and they're the one charging for the customers that were coming in.
I'd like to ask you a hypothetical based on something your friend said in his main argument. Assume with me for a moment that there were 11 alleged misrepresentations. Assume for a moment that there's a tribal issue of fact as to 10 of them. And on one of them you show as a matter of law there was a misrepresentation. Would you have grounds as a matter of law to rescind the policy based on that one established misrepresentation?
Yes, Judge, and the position is that any one material misrepresentation that had the insurer known the true state of affairs as to that misrepresentation, they would not have issued the policy. And some of the cases that are cited, and Judge Leibowitz cited Lima, one of the cases below, which the lease agreement in that case, the misrepresentation is that they misrepresented whether there was living quarters in certain parts of the home. So the rest of the square footage, the age of the home.
So in this case, the underwriter didn't say, as I understood it, that they would not issue the policy strictly. They said that they either would not have issued it or it would have been a higher premium. And in what you just said, you didn't include the higher premium part.
there is a second basis under New York law for rescission, and we cite the case law in our brief that when an insurance company can show that had they known the true state of affairs, they would not have issued the policy for the premium that was charged. That is an independent basis to void the policy ab initio, and there's case law that we cite.
And you put in your underwriting guidelines to show that is, to back up your underwriter's affidavit, right?
Right, and that is one of the criteria that is required, one of the criteria that allows an insurer to rescind the policy if if there is the material misrepresentation and it's inconsistent with the guidelines.
Counsel, can I just ask you one question? Your company, were they an excess carrier? Were they a primary carrier? Were they both? What was your, I was a little confused. I know they're called Hudson Excess, but were they excess or no?
They were the primary carrier for 2 of the policy years.
But they weren't excess at any point?
They were not the excess carrier.
They were never access to Lancer, in other words.
Well,
Or were they?
I'm sorry, I didn't mean to. Judge Lancer had coverage in another year.
Right,
on
it was
the
just separate
Right.
segments.
Yes.
Time.
Right, they were separate. They weren't, okay.
They didn't overlap, they were separate.
Okay,
Right.
thank
And if-
you.
Unless the court has any other further questions, we'll stand on the brief. Thank you very much.
Thank you, counsel.
Hudson's underwriter swore under oath the following. Vola operated a late-night adult entertainment lounge and strip club with exotic dancers. And if they had actually disclosed this fact, they wouldn't have insured them. It is a blatantly false statement. And if we're going to allow it to stand, because then they can say, well, there was a dance floor and all these other things, then I'm not quite sure what Vola can really do here. Vola submitted...
No, but you submitted, you submitted an insurance application that it had misrepresentations. Right, that's all we're looking at. There's a document that you submitted, that your client submitted, that made representations that were not true.
Your Honor,
Are you disputing that?
the crux of the trial court's decision is that Vola was operating a strip club, and that is false.
I'm asking
It's a
you,
false statement.
on this appeal, are you disputing that your client submitted an application for insurance that contained misrepresentation?
I am disputing that they can prove materiality for purposes of
Okay,
summary
that's
judgment.
a different thing. But you're not disputing that while you said certain things on your insurance application, for example, that you said no, to the question, did you offer entertainment? That's false. You said you did not say anything about DJs. You left unchecked the DJs. The hours, whether they were happy hours, late night, ladies' nights, alcohol promotions after 8 p.m. You said no to all of that, and that was all misrepresented,
Any of
correct?
the material, they could have gone to the trial court and said X, Y, and Z, dance floor, and all of these other things. They didn't say that. They went to the trial court with a fabricated affidavit from an underwriter.
Why do you say it's fabricated?
Because the statement of the underwriter is Vola operated a late-night adult entertainment lounge and strip club with exotic dancers. That is a categorically false statement. The owner of Vola responded to that at summary judgment and said that is a categorically false statement. I operated a restaurant and a bar. That's what he represented. If we want to get into a dance floor or a DJ, we can do that, but that's not what they did at summary judgment. They came in and they submitted a false affidavit, sworn testimony that is false, and that's the argument that they've used. On Lancer.
Any other questions? All right, I'll give you 30 seconds for Lancer. Finish the
Thank
thought,
you so much.
counsel.
I would just urge the court, if it would, to look at the intelligent digital case in the Eastern District of New York. This case is on all fours with it. There is Second Department authority. There's authority from all over the country.
I have
on
a
this exact
practical
issue.
concern. If this was appropriate, why don't we see this widespread practice of plaintiffs settling with insured parties and just leaving it to the insured to satisfy the release and judgment?
I think it is fairly widespread. If we look at the intelligent digital case, there's case after case around the country with this very thing occurring.
One case from one district court evinces a widespread practice?
It doesn't. It's not one case from one district court. They are citing 8
I'm
or
talking
9
about in New
cases
York, because
from around the
bad
country.
faith statutes
There-
are different in.
Of course, but there are plenty of Second Department cases. There are at least 2 Second Department, maybe 3 Second Department cases cited in here. When you're talking about McDonough, again, and we can go back and forth on this, but the issue of all liability, when you have someone, i.e. Vola, acknowledging liability via the consent judgment, and saying that...
Why wouldn't they? They're walking away. It's now the insured's problem.
Well, that's
the
exactly
insured's
right,
problem.
because they violated their contract in the first instance.
No, wait, they didn't acknowledge liability. They settled without an acknowledgement of liability.
I'm not sure how...
Yes, that's exactly what they
I'm
did.
not sure how a party can agree to a consent judgment against it and at the same time deny liability.
Well, I can read to you their document that said that they did not
No, it says...
They did
it says
not
they're-
concede liability.
No, that's no whereas clause, Your Honor, and there is embedded First Department authority on this very point. That whereas clause is not operative on the issue, and it cannot be read in conjunction with their agreement 4 paragraphs later to enter into a consent judgment. And let's also be clear here. There's a covenant not to execute. That only makes sense. That covenant only makes sense if, in fact, there is liability that against Vola. Thus, it had to contract out of that. And how did it contract out of it? By giving the assignment. Thank you very much.
Your Honor, briefly, with respect to the intelligent design case, there were 3 stipulations in that case, and the court specifically mentioned that there was nothing contained in this stipulation that shall constitute a waiver or a release of plaintiff's right to assert a claim against the defendant. We don't have anything like that here. They actually said, we're foreclosing any attempt to go after you. And with respect to the whereas clauses, the clauses that plaintiffs drafted, paragraph 1.1, which is at page 184, the recitals, which is the whereas clauses, are true and accurate. Plaintiff's words, not mine. That's where they
And in those, they denied liability, right? Or the
Specific- they denied
Vola did not, I'm sorry, I kept calling you, you know who I was talking about, right?
Vola.
Vola denied liability and just decided to settle there are many reasons people settle, not because, without conceding liability, right?
Exactly right.
Okay.
Thank you.
Thank you, Counsel. Thank you all. Okay, the next case is Brown versus Espinosa.
May I please the court? Dr. Silvia Espinosa, the appellant. So this is a case where there is a forensic evaluator report where he finds well-documented domestic violence in front of the child. There is a tape with an admission. Also, the respondent admits to the forensic evaluator that his hand touched my throat. So there are no custody recommendations per order, but he recommends domestic violence classes. However, Justice Waterman Marshall, admits that she has not read the report. Thus, on the April 26, 2022 transcript, page 23, lines 19 to 22, Goulart will issue his report. It will come sealed. I will not look at it. And the forensic evaluator has never testified in this case. Despite our requests, we petitioned way before the hearing that we wanted the forensic to be there. And so they just did not know that was going on.
So, Doctor, may I ask you, have you had the custody trial yet?
No.
When is that scheduled for?
I think May, the end of May.
Oh, so it's coming right up.
It's coming soon.
Okay.
Well, this is the first error out of 3. There is discretion before a forensic is appointed, but not after. The Court of Appeals of New York in SL versus JR 2016 discard the adequate relevant information standard, and they say, well, Supreme Court appeared to rely on, among other things, hearsay statements and the conclusion of a court-appointed forensic evaluator whose opinions and credibility were untested by either party. The order of the Appellate Division should be reversed. After a forensic is appointed, every single case, I haven't found any, there are none in opposition, Markowitz, Extra, Pontillo, Sotelo, Brown versus Simon, every single one reverses the decisions, even in temporary hearing. Brown versus Simon was temporary, there wasn't even a forensic appointed. They reverse based on the fact that they need the forensic to testify. This is a very important custody decision. But on top of that, even if you don't consider this error, there is another error. For example, this hearing was just 10 minutes per party. Each party just had 10 minutes. And also, the respectfully honorary water marshal precluded everything that happened before the only other hearing, which was also like less than 10 minutes per party. It was an emergency hearing, the only one before, in front of another justice. So this, well, and I can cite where she admits to it. In the July 3rd, the hearing that is being asked to vacate, in page 43, lines 10, 11. So please, sir, do not draw my attention to something prior to November 10, 2021. So this is the second error against Susana B. versus Lela G. from this first department, 2016. An abbreviated hearing is allowed, but there are conditions. It must include an opportunity for both sides and the children's attorney, when there is one, to present the respective cases and the factual underpinnings of any temporary order.
Thank you, Doctor. Thank you. We can read the case ourselves. Thank you. And thank you for your presentation.
Well, thank you.
Next case is Brito versus City of New York. Please.
Good afternoon, Your Honor. Peter Riegelhaupt of the Parisman firm for the plaintiff appellant. The trial court got it backwards. It was the plaintiff who should have been granted summary judgment, not NYCHA, because the fence panels were heavy, they were large, and they should have been secured for purposes of the undertaking.
But they were a fence, were they? Or they were a dismantled fence?
They were fence panels
Right.
that were attached to the bulkhead and were moved.
They weren't being used to exclude the public from the workspace anymore, right, at the time of the accident?
That's correct. In fact, they had to be moved so plaintiff could do his job. And we know that they should have been secured because everyone says so. The incident report says they should have been secured to prevent tip over. The witnesses testified to that. They said they should have been laid on the ground or put up against the wall. And it follows from that that they shouldn't have been left standing.
Did these fencing panels, as they were standing up, did they present an elevation-related hazard within the contemplation of 240 sub 1, or did they present a normal construction site hazard?
They absolutely presented an elevation-related risk, and no one has contended otherwise. They have said that it was an ordinary hazard of the workplace, but I think those cases are easily distinguishable. This isn't Narducci where the unrelated window falls. That's the case that they relied on. Narducci is a 30-year-old case.
A more recent case is Sparrow, which you cite and the city cites as well, tries to distinguish it. Sparrow, the one where the
Correct.
the sod and plywood fell over onto the worker.
Correct. The plaintiff was granted summary judgment in that case. That was not an ordinary hazard. That object was lighter and smaller than the fence panels here. So I think that case is applicable. I think where the Second Department got it, where the trial court got it wrong in focusing on those two Second Department cases, that at first blush, because they involve fences, might seem applicable, but they're really not. Because the focus in those two Second Department decisions wasn't on the character or the nature of the object. It was that there was no elevation-related risk. So
Also, I think that they were perimeter fences around an entire workspace, I think, in the two cases, unless I'm mistaken.
they were more in the nature of a perimeter fence. You're right, Judge Moulton.
But how is this elevation related when they weren't elevated?
Well, for instance, in one of the Second Department cases, Berman Ray, there was no work being done that day. The plaintiff was there just to retrieve his tools. And as he's walking to get his tools, the fence falls over. So there's no risk in light of the work being undertaken because he wasn't undertaking any work at the time. The decision in that case wasn't simply because, oh, it's a construction fence that's designed to keep out the public. And in the other case,
You're
Gurwitz,
saying that it didn't focus on elevation. It focused on whether or not there was work being done.
Correct, and in Gurwitz, the plaintiff was simply just walking along the construction site when the fence fell over. This is far different. This fence had to be removed so plaintiff could do his job. They had the material up there to secure it, and they didn't use it. I'll give you a perfect example. Hopefully you think so. Let's assume all the same facts that we have here, except the fence wasn't being used to exclude the public. It was being used to delineate the workspace of different trades, so keep their materials apart. Same exact facts, though. It had to be moved for whatever reason, and it falls over onto the plaintiff. Labor law can't exclude my client, but not the worker who's injured in the second scenario that I just
Key is that under the single decisive question of runner, the weight and height of the objects, the panels, posed a gravity-related risk.
100%. 100%. Yeah, you could go that route. You could go the gravity route, or you could say it needed to be secured for purposes of the undertaking. Everybody admits that. The only question really is whether you're going to exclude it simply based on the character of the object, and I don't think that's what the labor law is designed to do. It's really, the question is whether there's a risk or not, whether there's an elevation-related risk, and clearly there was here.
Maybe a gravity, it's probably more accurate to say a gravity-related risk as opposed to elevation, because it's not really elevated, right?
Well, elevated enough for purposes of invoking the labor law.
Okay.
Thank you.
counsel.
Good afternoon. Elisa Dultz from Fleischner Potash on behalf of defendant respondent, New York City Housing Authority. I want to point out something that's being lost here. As everyone knows, not every object that falls at a construction site falls within, Labor Law 241. And the object has to be hoisted, secured, or required securing for purposes of the undertaking. And the lower court correctly held that this fence did not require securing for plaintiff's asbestos abatement work. That's undisputed. The plaintiff, what was his work?
Did it require securing to permit the plaintiff asbestos worker to perform his duties safely?
No. I'm
Then
gonna
game
explain.
over,
No,
counsel.
Your Honor, it did not, because
Counsel, if that's the case, then isn't it, you're done?
no, the fence had nothing to do, maybe I misunderstood the
It had
question.
nothing to do with his work, but still, it had something to do with him doing his work safely, as Justice Higgins had said.
But that's in terms of negligence, okay? So yes, if I'm doing my work here and there's a fence behind me and there's a risk that it's going to be a windy day and fall, we're talking about negligence should the fence be here. But when we're talking about requiring security, it has to be secured for purpose of the undertaking, we're talking about this worker's asbestos abatement work, which was what? He was working by a bulkhead wall.
What about Spiro? No, in Spiro, the waterlogged plywood fell over, and it wasn't the work that the worker who was hurt was not working on the entryway that the plywood was across, right?
Yes, now the Spiro case is different. It is distinguishable because even though it didn't have to do with the worker himself, there was a door that had been put up as to cover another open door to protect to protect curing of some other tiles. So it was that door that was put up and that fell was being used at the construction site. It had a purpose. It was doing something.
Didn't this fencing have a purpose at the construction site?
Thank you, Your Honor. It did not.
It was just there gratuitously? It was absolutely there to protect the materials, right, at the time.
In the Spiro
And in order
case.
for, no, in this case.
In this case,
It wasn't there, this fence wasn't there gratuitously.
It was there. It was there to make sure that the residents did not come up onto the
And it had to be moved, didn't it, in order for this plaintiff to enter the area where he had to do his work?
Yes, it did.
So
but-
it didn't have to be secured during the time he was doing work so that it would not fall on him?
Whether or not it had to be secured so it didn't fall on him is a negligence issue.
Oh, I know.
It's not relevant to whether it had to be secured for purposes of the undertaking, which was the plaintiff's abatement work, which only involved taking out asbestos-laden bricks, putting them in a bag, and putting in the wood supports so the wall didn't fall down. From that work that he was doing, that didn't cause a risk of the fence falling. It had nothing to do with it at all.
Of course it did, because if he wasn't doing that work, they wouldn't have moved the fence. So that's the whole point. You're taking such a narrow view of, is it only the exact, I don't think our cases
Can I
say that.
talk about a case?
Sure.
Okay, thank you. I'll talk about, this isn't a concurring opinion, but it's the First Department, Macris versus Port Authority. So the plaintiff was holding a ladder for his coworker who was doing some work on some pipes, and a transformer that had been installed at eye level on a wall fell on him. And the court said that's not a Labor Law 241 violation. And in a concurring opinion, the judge said the transformer did not require securing for purposes of the undertaking. In fact, and this is the quote, the transformer was completely unrelated to plaintiff's task of holding the ladder while his coworker worked on a pipe in the ceiling.
I'm sorry, what year was that decision?
That was a
Is that post-Runner and Walensky?
2010. First Department, 2010.
Runner was what, 08 or 09? And so now we're on a sort of a different trajectory, right? And the single decisive question. And Quadroki, we got away from the strict two types of Labor Law 240, the falling worker, the falling object. The falling object's got to be, it's not just those objects being secured or hoisted, but those that required securing, right?
Correct.
And I think you mentioned
Yes, that
that
is the key
concept earlier.
issue. Was this an object that required securing for purposes of the undertaking? Even in
So
the
the key is how do we define undertaking?
Right, so his undertaking is the asbestos abatement work. So for example, we have a lot of cases where you have unsecured pipes, in the middle of a construction floor, and those pipes fall, and the courts have held that required securing. Those pipes are going to be installed. It was foreseeable that if you don't have a bracing or something device, that they could fall into.
But the fence is there for a purpose that is connected with the work that's being done. That's what I'm saying. I feel like you're taking such a narrow view of it.
Because the perimeter, it's just a fence, and it's not relevant to the construction
It's a
work.
fence that's protecting the property that's being worked on. Of course, it's not just a fence, and it's not a fence that was there. It's there as part of the construction work, right?
But it wasn't, that's the difference. We disagree, and that's the Second Department has held, whether the court chooses to follow it or not, that these perimeter fences are unrelated
This
to the
isn't a
construction
perimeter
work.
fence, right? This is not a perimeter fence.
Well, it was used, it's generally used, but here's another point. It's generally used as a perimeter fence in the sense that to keep the public out while the work is being performed.
Thank you, counsel.
Okay, thank you. So can I just finish my?
No,
Okay, thank you, Your Honor. Thank you for your time.
sure thing.
May it please the court, my name is Drew Packett, and I represent respondent third-party defendant Universal Construction Resources. So I want to note a few things and respond to some of the questions that were raised. For Labor Law 240, it's a very narrowly defined statute. It only applies to the narrowly types of elevated related risks. Here, this was a general worksite condition, and this had nothing to do with the asbestos abatement work.
Let me ask you something. Let's assume that whoever erects that fence, when they were done doing so, they left a heavy wrench on top of one of the support poles. And then the worker, the plaintiff is doing his work, and that wrench falls and hits him. Would that be covered?
That would not be covered under 240, or I guess I want to be clear here. That would not be a 240 violation because the fence and the wrench had nothing to do with the worker performing his work. So for example, I know the Sparrow case got mentioned. There, in Sparrow, the worker that was struck by the falling plywood, that plywood was there to assist with the work, okay? That plywood that was there to assist with the work was not secured.
But I
As a
think
result,
you're saying it's only the work that that particular person is doing, and that's what I'm having a hard time with, because the pipes can fall on the carpenter. It doesn't have to be on the pipe guy,
correct, but
right?
so there are a
It can
bunch of
be on-
cases.
You know what I'm saying? So why is it just have to be connected narrowly to the asbestos guy? It could be anything any part of that construction. And in fact, I don't even agree that the fence isn't connected to the asbestos work.
So two things. The answer to the first part of your question. Again, Labor Law 240 is narrowly defined. It talks about this it focuses on the job, the purposes of the undertaking. What needs to be done? What needs to be secured for the purposes of the undertaking? A security fence has nothing to do with the asbestos abatement being performed here. It's just a general worksite condition. It's no different than in Narducci when an unrelated window happened to fall down and hit a worker. In connections,
I mean, I'm not sure I agree with you that our cases say that you're supposed to interpret it so narrowly. I think it says that it's supposed to be interpreted broadly to protect workers. And so I sort of disagree with that concept, but go ahead.
well, I guess it's in our papers, the Nieves case, the quote, the extraordinary protections of Labor Law 240 extend only to a narrow class of special hazards. Here, again, we have a situation where there's a security fence that's completely unrelated to the work. Okay, whether or not it should have been secured, that is a separate question from whether or not there's a Labor Law 240 violation.
I want to ask you a question. What if the fence was much heavier and much taller and placed in the same place and was clearly a danger to anybody who was up on that roof in a windy day? It wouldn't matter because it was a fence
Again,
and had nothing to do with
labor-
asbestos abatement? Is that your point?
for Labor Law 240 specifically, yes, it would not be a violation of 240. It would be a violation of, there'd be a negligence, 200, but with respect to 240, 240 is narrow.
Okay, thank you,
Only
counsel.
focuses on
Thank
the
you.
undertaking being performed.
You can
at the
sit
time.
down now. Thank you,
Okay,
counsel.
thank you.
Two very quick points. This court has said in cases like Diaz and Gregorian that the object doesn't have to be connected to plaintiff's work. In Gregorian, I think you were on that panel, Judge. You said you used the word irrelevant. It doesn't have to be connected to plaintiff's work at all. Look at the Tisselin case that I think the three of you in the middle were on. The plaintiff's just riding up in a hoist, and the ladder, and it's an emergency ladder, only used in case of an emergency, falls from the ceiling. Plaintiff is covered. Object should have been secured. And Justice Scarpula, further to your point about how this fence is connected to the project, they had a mock-up before this job ever began in the parking lot where they did a demonstration of how it was supposed to be erected and connected. So it clearly had a connection to the site, and once you move it for plaintiff's job so he could do his job, that's even more to the point. Thank you.
Thank you, counsel. Thank you all. Mama, the New York City Department of Education. Please.
Good afternoon. May it please the court, Robert Godosky for the plaintiff appellant, Rama Mama, who was a teacher at the Department of Education. The lower court erred in this case in simply placing the burden of establishing certain facts on the plaintiff when obviously they should rest on the movant defendant in this case, specifically as to notice.
Counsel, okay, say they didn't talk much about constructive notice, but what would they need to say about constructive notice? I mean, do they have to inspect every single desk in the school?
No. But they had to have, and the law has been very clear that in order to meet its burden, it has to produce evidence of some type of inspection, cleaning that's done on a regular basis in the property to meet their burden of making sure that the property is a safe place to be. So in this instance,
Usually
they
employ that standard for transient conditions, conditions related to slip and falls, as opposed to the condition of an object?
It's not just for transient conditions such as fluid or fish guts, I believe is one of the cases. They are for, in fact, things such as defects in the property itself, and furniture defects are things that should be inspected. When, in this instance, the teacher was there on a Thursday, that desk had been there for as long as anyone knows, and the inspection that was allegedly done and what they rested on was a school engineer similar to that which was submitted in the Danvers City case a year ago, where they found, with this panel, this court found that it was inadequate to meet the burden of showing constructive notice. Again, the lower court, and in fact stated, the defendant stated in the lower court, that the plaintiff's complaint failed to show that the city had actual constructive notice. In the motion for summary judgment,
So you're
it
not
is the
saying-
defendant who must show.
You are not arguing that anybody had the obligation to go in and look at the desk. You're just saying, in general, someone had the obligation to look at the property and make sure it was free from defects.
Other than the fact that, I'm not sure if you're focusing on the word general, a general routine inspection may not be sufficient. So someone who's going in.
So you are saying that someone has to look at every desk?
No. The courts have utilized the word that a routine general inspection is insufficient to meet the burden of showing that there was
Again, I'm trying to
constructive
figure out
notice.
what is it that you think that the defendant would have had to show?
They would have had to show a regular course of inspecting the property, including the classrooms. They did not do so.
What does that look like? If the engineer had said, I have a routine of every day, I look in every classroom and I see nothing and I go on, is that sufficient?
I'm not exactly sure in terms of when you say looks on in the classroom.
He looks in the classroom because what happened here, the defective condition here was a desk that apparently was missing one of the adjustable legs, right?
Correct.
So we're looking into a classroom, whatever that may look like, right? Just saying I looked into the classroom to look for dangerous conditions and you missed the leg, apparently as the teacher did. Then what?
Right, but the teacher, again, the obligation on the landowner.
I understand the obligation. I understand that. I'm just saying, what is it that you're asking? What's the requirement?
What I'm asking is for the inspection or the cleaning, the regular course of responsibility by the landowner should be to spot where a door was malfunctioning and didn't have a door stop. And as such, that door created a dangerous condition.
I mean, this particular engineer did testify, I believe, that he inspected the classrooms every morning, but he really only did so to make sure, like, the heat was on and not to determine
Literally.
that the desks were intact. So and they had a logbook, but it didn't really reflect any kind of inspection. So in order for the defendant to have met his burden of proof on this motion, on their motion for summary judgment, they would have had to do more than what they did here.
Absolutely.
I mean, we're not saying that every day he had to go into every classroom and touch and inspect every single
Correct.
desk. That's not what
Correct,
you're
Your
saying,
Honor.
but there had to be some type of routine more than what there was.
Correct.
Wasn't there a logbook that said he inspected the classrooms every day?
There's a logbook, just like there was a logbook in the Danvers
I'm
City case.
asking you, I'm not asking about any other case. I'm
No,
asking
there's a
about
logbook.
And what does the logbook say?
Nothing other than he checks the heat and the fire alarms.
And, that's it. But he
That's
goes
it.
into the classrooms every day.
Every morning, 7 a.m., before anybody gets there, he goes to every classroom, makes sure the heat is working and the fire alarms are working.
But not
Period. Nothing
inspecting
else.
for other defects.
Nothing else.
Okay.
Thank you, Counsel.
Thank you, Your Honors. Karen Wolf for the respondents. I will be brief, as I can tell the court is very familiar with this record. Just if I could pick up with Justice Kapnick's question with respect to what duty the respondents would have had to demonstrate a lack of constructive or actual notice. First, it's undisputed on this record there was no actual notice. It's also undisputed on this record the city did, DOE, did not create the defect. So the question is really constructive notice. And as my friend said, the plaintiff was working consistently in this classroom for several months. This was her regularly assigned.
No, but that's not, it's irrelevant. It's your burden. So how did you show that you were regularly inspecting the classrooms for defects?
Well, let's examine the question of where the duty comes from to regularly inspect.
I just want you to answer my question, please, which is, how did you show that you regularly inspect the classrooms for defects? What did you put in? Are you saying you don't have an obligation to regularly inspect for defects?
The court need, on this case, the court need not reach the
Right.
question of whether there's a regular duty to inspect. The question is whether the city had constructive notice. And
So normally one would show that you didn't by showing regular inspection for defects. So again, let me ask you, what did you put in that regard? Not what the plaintiff said or did, what did you on your motion put in?
So one way to demonstrate a lack of constructive notice is to show regular inspections. And that's typically done in cases, and these are the cases cited by the plaintiff, where there's an anticipatable or an anticipated transient condition, a spill, a loose grate on a grocery store floor, or litter on a stairwell that may obstruct someone passing through the stairwell. Those cases are distinct from this case where we're not dealing with a fixture. It was furnishings within the classroom. Those classrooms were set up at the beginning of the year.
And yeah, we're not talking, but it could be that there's a missing tile on the floor. That's the kind of defect, right? So how are you showing that you are regularly inspecting for that type of defect?
I think, unfortunately, I think that begs the question that there is.
I just want to, again, have you shown that or not? Have you shown that you regularly inspect the classrooms for defects?
That presumes that there is a duty to.
Well, look,
Right,
you
but the
don't
answer
have-
is no. The answer is no, and you're saying there's no duties, but go ahead,
right.
Justice Higgins.
You don't have a duty in tort to inspect, right? What you have is if you want to discharge your affirmative burden on summary judgment, one way, although in some cases it's mandatory to show, you did have a regular routine inspection, and you have to show what the results of those are. So the question, right, in my mind is, what did you do to show affirmatively that you lacked constructive notice?
So affirmatively, that we lacked constructive notice, the classroom was in use regularly by the students and by our plaintiff, who was regularly assigned, and no reports of a defect with respect to the desk or anything else in the classroom was reported, notwithstanding that DOE actually had a reporting process. And the custodian engineer, Mr. Jimenez, testified that had a defective desk or piece of furniture been reported, it would have been discarded.
That would have been actual notice, right? If you have a report of a defective desk, that's actual notice, not constructive.
It's actual notice, but the inference that arises from the fact that the classroom is in constant use and no reports were made is that either the defect arose very close in time to.
Or nobody used the desk.
I'm sorry.
Or no one used the desk.
Actually, Ms. Mawa testified that the desk was in use. That is her testimony, her deposition testimony, and that there were no complaints, even that the desk was uneven or unbalanced. So she did put that into the record. If I could briefly address the Dan case, since this court very recently ruled on that case, and with some chagrin, I must say that was also my case. Dan is distinguishable from this case. In Dan, the city affirmatively put forth inspection reports. Dan involved an exterior door to a school building. The custodian engineer affirmatively testified in that case that she walked the perimeter of the building, checked for safety, including the exterior doors, and including that they functioned correctly, so opened and closed correctly. This court held that was insufficient, that expert testimony was required to show that the door was functioning correctly. So the custodian engineer's testimony in and of itself wasn't sufficient. So that case is very different from this one, and in that case, the city affirmatively brought that evidence forward to the court. If I could just briefly end on the one point my friend raised, which was that the lower court impermissibly shifted the burden, on summary judgment to the plaintiff. That isn't correct. The decision in toto clearly sets forth the burden shifting standard and clearly correctly applies the law. The court held DOE met its burden, made a prima facie showing, and that the plaintiff failed to rebut that showing.
Thank you, counsel.
Thank you, Your Honors.
Unless the court has any questions, I have nothing further.
Thank you, counsel.
Thank you.
Stromberg versus East River Housing.
May it please the court, my name is Mitchell Haddad, and I represent the appellant East River Housing Corporation. Appellant's denial of a purchase application based on a low sale price was within the scope of its authority, made in furtherance of legitimate business interests, and protected by the business judgment rule.
Counsel, you brought this motion before there were EBTs. And, you know, the question is, you know, in the case is whether or not there's a blanket policy of some floor for apartments of similar description being above that floor, a price floor. Now, should they have had the deposition of Shuli Woolman?
So the answer is, Your Honor, no. That goes to the fact that as a challenger, which the respondent's opposition brief admits they are, they have an initial burden of showing by admissible evidence that the business judgment rule does not apply.
I know, but some of that might, I mean, arguably, and they make the argument, that knowledge reposes with your clients, and therefore Mr. Woolman's EBT was essential, and perhaps some others.
But there's no evidence here of a price floor. What you have here, similar to what happened in Singh v. Turtle Bay Towers, you have a co-op making an ad hoc determination on a single apartment that price is less than what the co-op reasonably believes to be the market value.
On the same day that you rejected this deal, you approved a deal for $615K for a similar apartment, something like that?
So the very same night
Yeah.
where this apartment application had been rejected, a similar one-bedroom, no-balcony apartment had been approved by East River for $675,000.
75, okay.
$155,000 more. The evidence in this appendix shows that there were 70 sales of apartments from January of 2021 to the night.
But wasn't there also testimony in the record that the landlord, the sellers were making a lot of concessions to the buyers in order to get the prices up and at the last minute, and that a lot of these apartments were different, that you didn't take into consideration whether they had been renovated, sometimes whether there was a balcony, and some were located much better and had much nicer views or were much noisier. I mean, all these things go to comps as to what apartments are worth, and that was part of what was in this record.
So, Your Honor, the lower court threw out as inadmissible all of those comps from 2022 that discussed the seller concessions, because that was based on inadmissible hearsay. The broker allegedly heard that from other brokers. There's no evidence of that in this record. Number two, with respect to the...
Now, that was Mr. Goldman, right?
Yes, sir.
Okay, Mr. Goldman, he's Loho Realty? He's Loho Realty?
Yes, sir.
And wasn't that the most active broker in East River Housing?
No, that's what they say.
He said they're number one in broker sales.
That's what they say.
Yeah. Okay.
There's no evidence. And even if he was, it doesn't matter, because what you're dealing with here is the business judgment rule. And they have the burden on summary judgment of demonstrating by admissible evidence that it does not apply. And
No, only to grant summary judgments to them. They just need to raise an issue of fact.
Well, actually,
that's the
not
whole.
true.
I disagree with you, counsel. I think if they have to raise an issue of fact as to whether or not you are setting a price floor, because that would be an unreasonable restraint on trade and beyond the business judgment rule, right? Can we?
I disagree with that.
Okay.
And I'll tell you
You're
why.
telling, let's assume that I believe the law is that if there is a uniform floor for apartments, that has been held by more than one court as an unreasonable restraint on trade and would be outside the business judgment rule. Let's assume that I think that that's the law. Do you think that the tenants have raised, or the shareholders have raised an issue of fact with respect to that issue?
The answer is no.
Okay.
And I'll tell you why.
Yes.
Summary judgment. And this court dealt with this, and it's really tricky, and I was reading the case today again. It's the Jones case, Surrey Apartments. And in the Jones case, the lower court flipped the burden of proof by requiring the co-op on summary judgment to prove that none of the items for which the business judgment rule wouldn't apply were not applicable, and therefore that the business judgment rule applied. And the first department said that the lower court, there's a different standard. All the co-op has to do is show that it made the decision, it was within a legitimate basis, it was within the scope of its authority, and that there's a rational basis to do so. In Jones, the burden then shifts on summary judgment. It says, and I'll read it, plaintiff who bore the burden of making the requisite showing that the board of directors breached its fiduciary duty utterly failed to meet this burden. The court below, however, found this circumstance to be of no consequence because, as stated, on a motion for summary judgment, it was the movement's burden to establish the non-existence of those elements. This was error.
Thank you,
So,
counsel.
In a normal situation, I would agree with you. But when the business judgment rule applies, there is sort of a shifting burden here.
Thank you very much. You have time in rebuttal.
Afternoon, Your Honors. Jeffrey Metz for the Strombergs. Your Honors, the order should be affirmed.
Let me ask, do you agree with me that the board asserts business judgment rule as it absolutely shall, as it's, and proves that, or puts in its proof that this is within the business judgment rule? Then you raise an issue of fact if you show that the board acted outside the scope of its authority in a way that did not legitimately further the corporate purpose. And that raises an issue of fact requiring a trial. Is that, do you and I, based on 40 West 67th Corp., agree that that's how this goes?
That is,
So
that's our position, Your Honor.
so the landlord asserts business, or the co-op asserts business judgment, and you say it's outside of business judgment because you're setting a floor for all the apartments.
That's correct.
And the floor is an unreasonable restraint or an alienation on my right to sell my shares. That would be outside the business judgment.
That's,
That,
What
that's our
about,
position.
what about Mr. Haddad's allegation that the affirmation that you put in was not admissible, so this stuff is not appropriately in the record?
I think my opponent has said things that are not exactly consistent with what Judge Leibowitz said. With respect to the Goldman, he said that a few items were hearsay, but at this juncture, as long as there was other proof, it was admissible. Now, what we have here is you have Goldman. He puts in a sworn affidavit. He has 50% of the sales there. He's
a shareholder too, right?
He's a shareholder. He's lived there, and he knows what's going on in this building. Now, what's very key, and you said this, Justice Moulton, what about Mr. Wollman? What about him? They put in an affidavit of the president, but according to Goldman, the architect of the floor is Wollman and this other fellow, Kaplan, from the management company. Now,
let me ask you a different question. You're not disputing that the board can look at price in determining whether.
no, not at all.
Right?
That's not our point. Our point is that cannot be the
Sole criterion.
Exactly, and that's the reason why the declaratory judgment cause of action was dismissed.
Because you agree, with what they wanted declaratory judgment for, you agree. I mean, of course you can concern the sales
We
price.
said that down below. We don't challenge that. Of course they can look at it. That's what they're supposed to be doing. But they can't breach their fiduciary duty by restraining trade here. And my clients, you remember, they it was 525. That was rejected. They got somebody to go up to 540. That was rejected. A year and a half later, they put in a bid for 600. And of course, how this works, it's totally inflated, Your Honor. I mean, what they do is they get a credit at closing.
They get concessions.
Exactly. So the seller has to pay extraordinary sales tax and flip tax. And that's just wrong. And again, we're happy to go to trial. We're happy to go to trial on this. We need to get discovery. We haven't had it. They moved 2 months after their motion to dismiss was denied.
Hey, counsel, speaking of streamlining trial, your breach of contract claim has got two notice parts to it. The main breach of contract claim that you're bringing, of course, is about the price fix.
Yes, Your Honor.
Can we get rid of the two notice parts of your, because you don't try to defend them?
There's nothing in my brief about that, Your Honor. I am content. I mean, if my opponent is very hyper-technical. We had some hyper-technical arguments going the other way, but this is the key argument here.
So we can agree that that is no longer part of the case?
Correct.
Okay.
Thank you, Your Honor.
Thank you, counsel.
Your Honor, there really is a threshold issue. And the threshold issue is that they have to come forward with admissible evidence to show that the business judgment rule doesn't apply. And on this record, they don't have it. They've got Stromberg's representation made upon information and belief, which as a matter of law is insufficient to deny summary judgment. The appraisal is absolute hearsay. They didn't satisfy a business.
Why is the appraisals hearsay?
The appraisal is an out-of-court statement by an appraiser seeking to prove the truth of the valuation. It is not a business record. The appraisal wasn't prepared for the plaintiffs.
It was commissioned by Jones, the first buyer, right? The appraisal was commissioned by Jones, I believe.
It was commissioned by the bank for lending purposes.
Yeah, for Citibank, because she wanted to get a mortgage from Citibank.
Correct.
Yeah.
Well, everybody, that happens with every apartment.
But East River did not have that appraisal at the time that it made.
Well, there's a dispute about that
But
from
even
what
if
I
it
read.
did, the business judgment rule doesn't require the co-op to forfeit its business judgment, because what it had in front of them, and I really want to emphasize to this court on Appendix 190 to 191, there are 12 similar one-bedroom, no balcony apartments whose average sale price was $597,000. Mr. Wellman is alleged to have said that the price should be $600,000. That's not a price floor. That's not price fixing. What it is saying, this is what the co-op believes the fair market value is. And your price of $520,000 is $75,000 and 13% lower. And therefore, under Singh v. Turtle Bay Towers, this co-op has the right under the business judgment rule to deny this purchase application based on a low sale price. The last point I just want to make goes with respect to the attorney's fee provision. And we did ask the court to reconsider Crodel, but if it doesn't, RPL 235C permits the court to enforce only the provision to the extent that it would.
Did you make that argument below, though, counsel?
Yes, we did.
Okay.
And the court disregarded it. But there's one thing that isn't in my brief that, as I was reading the statute in preparation for today, the second clause of RPL 230C says when the clause finds that something's unenforceable, it has to give the parties an opportunity to submit evidence concerning the making of that clause and the making of the contract. And that didn't happen here. And this contract was part of an offering plan that was approved by the Attorney General, that was voted on by all the shareholders. I think that might change the evaluation, and this issue wasn't decided or considered in Crodel. And so I think even if Crodel stays, there is a significant basis for someone to take another look at this attorney's fee provision, and we respectfully request that the order be reversed, summary judgment be granted in front of East River, and the cross motion.
Thank you, counsel. Thank you both. Picken v. RN Realty.
I've been staring at that for an hour.
Okay, you ready?
May I proceed?
Yes.
Please.
May it please the court, Robert Tolchin for the appellant. It's been a long afternoon, so I really want to just get narrowly focused on what I think is among the most important issues here. In reviewing respondent's brief this morning, I couldn't help but notice that in describing the standard, my brother states on 5 different places that not only does the seller have to thwart the transaction, but it has to be wrongfully frustrate, wrongfully thwart. Obviously, anytime a seller has an opportunity to sell to buyer A and chooses to sell to buyer B, the seller is thwarting the sale or frustrating the sale to buyer A because he's selling to B. So there has to be something more. There are instances where a seller is permitted to sell to a different buyer.
How do we, oh, I'm sorry, go ahead.
Well, I wanted to know, is your main argument that there was, look, you did not oppose the charge that was presented by Judge Maisley at the trial, correct?
Just to be clear, it wasn't me, but
Okay,
my client's trial attorney, having raised, the way I would answer that is having raised the issue at the beginning of the trial and having had the judge say, yeah, I know that's in the appellate division
But
order,
I'm not gonna-
but I disagree and it shouldn't be in there and it's confusing. And when they discussed the charge, she said, I'm not putting that in. To
So
then
there was
have
no
to-
further, so there was no further objection. Okay,
Correct.
so if we were nonetheless going to consider that, is your focus really that there was a fundamental error because because the trial court did not adhere to what we said she should adhere to 3 years ago when
the summary
we,
judgment
when we issued our decision? Or are you saying, well, the fundamental issue was that the judge did not give a charge consistent with the state of the law?
My core argument is that it was a fundamental error because the trial judge did not adhere to this court's decision in the first appeal in this case.
Which said that in addition to asking whether or not the defendant thwarted the transaction's natural progress, I'm reading from the decision, she needed to go on to say, and was that done in order to avoid paying plaintiffs their commission?
That's correct, and I'm tying it into that word wrongful, because even they acknowledge that it has to be a wrongful frustrating of the sale. And the potential wrongfulness that this court identified on the previous appeal is that you were doing it to wrongfully avoid paying the commission. We then tried to bring out in our brief that there are valid reasons, there are legitimate reasons why this seller would have chosen to go with a different buyer. He didn't like, he was from Connecticut, he hadn't done deals in New York, he thought he had been in bankruptcy, he was doing a joint venture, which isn't just a straight sale, it's an ongoing marriage. So
it can't, it's not enough to just show that the deal was was moving along and then you didn't do it. You have to also show the reason why you didn't do it is to avoid paying the broker the commission.
Exactly.
I mean, I looked at the chart, when the clerk read question number 5, what was your answer? And really, there just needed to be about 6 or 7 more words into it, and you wouldn't be
Correct.
visiting us
The
today.
way the trial judge phrased it, if you just didn't sell it to customer 1.
That wasn't good enough.
Well, the way it was phrased, the jury would have said, well, he didn't sell it to that customer, so he must have frustrated it. But there are legitimate reasons. Let's say you found out he was an axe murderer. You know, there's reasons why you might want to not proceed with that. And by saying I'm not, you know, the appellate division was confused, I'm going to take that out, I don't think that's right. Well, that's not right. That's why we make summary judgment motions and have interlocutory appeals. And then it's not the general state of the law of the state of New York. You have a law of this case that you follow. And if you thought it was wrong, you could move to re-argue. You could, there's procedural avenues to raise that, but you don't just get to disregard it because it's a shortcut.
Thank you, counsel. You have time in rebuttal.
Thank you.
May it please the court, Daniel Hoffman, Moses and Singer for respondents Alexander Picken Real Estate Incorporated. There is no basis to overturn the verdict. The trial court did not err in instructing the jury. And even if, for argument's sake, there was an error, which there was not, there was
Well,
more
for
than
argument's
ample
sake,
evidence.
honestly, the appellate division decision, it's very short the last time. It wasn't really too hard to read. It only had a few sentences in it. And the judge, the appellate court our court specifically said the trier fact has to determine this. And the question that was posed to the jury by the judge in her charge did not include, it only included half the sentence. It didn't include the wrongful aspect of it. And it seems to me that that is the law, and that is what we said, and that's, you know, the law of the case as well as the law that exists. And how can we ignore that?
Because, Your Honor, there's a body of case law going back decades in New York, including prior decisions from this court, that indicate the seller's motivation is not relevant. That is not an issue, that is not an element that the jury has to prove. Now, certainly the seller's state of mind, and we did prove it. There was overwhelming evidence introduced
So
before
now
the jury.
we're now essentially then re-arguing what was said in Pickett 1.
No, we're not re-arguing. In Pickett 1, this court decided the question of whether or not the summary judgment motion should be affirmed or denied, and the case should go to trial.
I'm going to quote exactly what Judge Kapnick was just referring to. In such circumstances, the trier of fact must determine whether defendant thwarted the transaction's natural progress in order to avoid paying plaintiffs their commission by shopping the same deal to another party. So, right, wrong, or otherwise, we decided to frame our rationale around what the trier of fact must determine. Yes, our ultimate conclusion was to deny summary judgment, but we take it as we find it, right? The trier of fact must determine ... And so why would there be a deviation from this?
This court was presumably the narrative of the case and the evidence that was submitted to the jury established this very issue. So even if it was an error, which it was not, it would have been a harmless, there would be no prejudice.
No, it can't be, because as far back as 1933, the Court of Appeals has said that a seller in good faith changed its mind and backs out of negotiations is not obligated to pay the broker, but the seller who backs out in bad faith as a device to escape the payment of the broker's commission. It's not just you back out when it's close. It has to be you back out in bad faith to avoid the commission. That was not charged here. And there, I can read, so talk about lots of cases. That's Goodman, Sibbald, Aegis, Douglas Elliman. That's the law, and it always has been. It's not enough to be close to the end and to back out. It has to be because the seller is acting in bad faith to avoid the commission.
Your Honor, respectfully, in Trilon, this is a Court of Appeals decision from 1974, the Court of Appeals says, quote, the thwarting need not be born out of bad faith. And there's other recent decisions.
No, to avoid the commission.
Prime City Real Estate that this court decided in 1998. In that case, the seller received a higher offer and then stopped negotiating with the broker's buyer. There was no finding in that case that they stopped negotiating to avoid a commission.
You're saying that was an implied brokerage agreement or a straight up? I believe those are straight up brokerage agreements.
Ultimately, whether it was an implied
No, that's a
or expressed.
complete different thing. It's completely different. An implied brokerage agreement relies on this, including, I mean, I can cite you Douglas Elliman. These are cases from the last 7 or 8 years. It's just not enough to say one without the other.
There's another case, Linda M. Kirk Associates. This was First Department in 1989. In that case, the court indicated the seller, quote, decided not to proceed. There was no discussion of motivation as a requirement. There's no discussion that one needs to understand why the seller did it or that they did it specifically to avoid a commission. And the reason being because this is part of the prevention doctrine. The idea is if the broker does everything they need to do to make the sale, and at the last minute the condition, i.e. the sale, doesn't go through because of the whims, the arbitrary whims of the seller, whether that be specifically to avoid a commission or for any number of other reasons. If arbitrarily the seller
You're saying that if the
prevents
seller gets
the
another,
from
if the
occurring.
seller gets a better offer, another $10 million, and they go for that, they can't do that?
They can do it, but they owe the broker the commission, and that's what this court's prior decision.
I don't think that. I
Linda
think
M.
that that
Kirk.
only applies in a brokerage commission agreement case, where if you procure someone ready, willing, and able, that is not this case. That is a different case. That has always been the law. If you have a brokerage commission and you procure someone ready, willing, and able, and the deal doesn't go through, you get paid. That's not this case. This is an implied brokerage commission.
If I may add, Your Honor, in any event, the record before the jury would establish there was no prejudice. They considered this issue. Schwartz, who was the
The
principal
evidence
for
was
the
before it,
RN,
but to use the verb considered, that means they were instructed of the import or the materiality of that evidence and how it related to what they were going to determine.
the evidence before them established that he did avoid the commission for the sole, he avoided the sale to avoid paying a commission. His own words, he said, quote, "I'm not dealing with any brokers." In another email, another broker emailed him and said, "You were clear you weren't wanting."
I just want to sort of piggyback on what Justice Higgett said. There's a lot of evidence that comes in a trial. I know this was a limited trial, but there's still a lot of evidence that the jury has. The judge's job, we all did this, the judge's job at the end of the case is to instruct the jury about what they have to consider and what they consider to get to the answers to the different questions. And so without putting that all together for the lay people, or even if they're lawyers, people that don't necessarily do this, is the error. And I think it's hard to call that harmless error.
Thank you. Did you want to, I'll give you 30 seconds to
I
respond.
would, thank you, Your Honor. There were multiple emails. The seller's own attorney testified at a deposition, and he said, quote, "At that point in time, Schwartz, the principal, saw no reason to deal with brokers." This is already after 2 years of him benefiting from the services of this broker. The attorney had said, "We have a deal." They were plainly and evidently approaching success, as the jury found. And then in private communications, he says, "Well, we don't want to deal with brokers. We don't want to deal with commission issues." So the whole question of whether or not, even if one had to prove motivating based off of commission avoidance, the evidence overwhelmingly established that that is exactly why RN thwarted the deal. In their own emails, they say they wanted to avoid the commission. Thank you.
Thank you very much.
Unless the court has any other questions, I'll wait.
I have one question. What evidence, if any, was adduced at trial, whatever the source, that supported the position that I'm sorry, I'm just trying to tether it to what we said in our prior decision, that you did this for what I'll call a good faith reason, that
Mr. Schwartz testified that he didn't like this buyer. The buyer he ultimately sold to paid not only $1 million more, but he considered that buyer to be a better joint venture partner for the $15 million interest that he was retaining in the property. And the other broker, Mr. Putko, had told him that Pick and Putko's buyer had had a brush with bankruptcy, which he didn't like, and they were from Connecticut, and hadn't done projects in the city before, which he didn't like. So those were his reasons, and he testified to that.
So essentially, you're saying there was evidence going both ways.
Correct.
So, and it was a jury question to decide whether or
Well, it
not.
was a jury question, but as just
Do you agree that in an implied brokerage case, as opposed to a straight up brokerage case, you have to show that the purpose was to avoid the commission?
I agree wholeheartedly, and I'd go a step further and say it's time to get rid of these implied brokerage. We don't let anybody else do that. A lawyer who would say it's an implied legal fee, you disbar him. And there's so much fighting and so much craziness of, why can't they get it in writing? Why not agree on the commission before you do the work? But I do agree with your statement, and I also agree with Justice Kapnick that it's the judge's role to tell the jury what to do with all this evidence and how to weigh it.
I guess I was asking because counsel sort of made the argument that the evidence all showed it, even if the jury wasn't asked it, but you're saying that there was evidence going both ways.
Well, there's always, when you read a trial record, there's always evidence going 10 different ways, and trial lawyers, when they do their summations, figure out how to pitch it, even if they only have 5 minutes to plan their summation at 5 o'clock on a Friday afternoon.
Thank you, counsel. Thank you both.
Thank you.
99 Wall Development Incorporated. Please.
Chris Georgioulas for 99 Wall. I want to address the breach of contract and the willful exaggeration of liens first because they're related factually. The parties entered into an agreement in February 2015.
Counsel, get a little closer to the microphone.
I'm sorry.
Thank you.
The parties entered into an agreement in 2015, February of 2015, where Consigli would convert an office building into a residential condominium building. There was a written contract, and basically the only obligation that 99 Wall had was to pay. They do the work, and they pay, and they would pay in accordance with the terms of the contract. The obligation, of course, of Consigli was to build the condominium.
So there's this contract there. Then why do you get negligence and gross negligence claims out of it?
Because we're going to get to that, but there are three issues here. On the gross negligence is because there was two water events. One was catastrophic.
No, we know the facts, yeah.
So, but I'd like to just finish the breach of contract, because it's very important. So they don't complete on time. What happens is the contractors are delayed, it goes forward.
You had an amended contract.
We had that's the key.
And they say you didn't pay them under the amended contract. So don't we have an issue of fact about who breached first?
No.
Okay.
There's no
Go
issue.
ahead. Tell us why.
The contract says, the amendment of the contract says substantial completion, June 24th, 2017. Final completion, July 1, 2017. We made every payment. There was not one outstanding invoice, as the trial court found. No invoice is unpaid. So they should have finished, and they didn't finish. We don't default them. We continue to work with them to try to get this job done. In September, there's one payment due on September 1. However, during that 2-month period, we send a notice. We're not going to pay any more money because we have a right to withhold. They're in breach. They're not finished. There's not enough money to complete the job. There's a ton of defective work. The engineer of record sends a 22 list of defective work. They send a letter saying we're going to suspend performance. You owe us $394,000 due on September 1. That letter is dated September 2nd. We say we're not going to pay. We're not paying. Fast forward, in 10, 12 days, they're off the site. So now they've claimed in that letter that we owed them $394,000. 5 days later, they file a $1.1 million lien.
Counsel, you can assume we know all these facts. Tell us what we should draw from them.
That as a matter of law, the liens were exaggerated, willfully exaggerated, because 6 weeks later.
Let's talk about the willful part of that.
Go ahead.
Okay, well, actually, you have to tell me about it.
Yes. Well, how do you, on September 2nd, you're claiming we owe you $394,000. There is no invoice. Then 6 days later, you file a $1.1 million saying we owe you $1.1. Then 6 weeks later, they file a $4 million lien, total $4 million.
Yeah.
For items that were previously paid, for items that were specifically waived in the amendment, for items that are not lienable as a matter of law. You can't lien for profit.
And so you're saying that like roughly $2.5 million are they were willfully exaggerated.
2.7.
And how do you come up with that? Why, the willful part? How do you come up with knowing
Because
that
as
amount?
I argued a case, Casella, before this court a year and a half ago, where the issue was basically saying one of the 4 items, where the contract had been previously paid, files a lien for an amount of 200-some thousand, asking to pay again. This court said, no, you can't do that, and it's willful as a matter of law. When you waive claims specifically in the amendment to the agreement in the amount of $1.4 million, and then you add them back to a lien, what's the purpose of that? There are no invoices saying that that money is owed. It's strictly to extort, basically, a leverage position. Because when you file $4 million in liens, you have a building, you have loans, you have potential owners who want to buy the condos. It affects everything adversely for the owner. So they have to do something. And what did they do? They had a bond. They had a bond for $4 million in order to get rid of the liens. The contractors know that that's a leverage position. They're basically trying to extort some kind of a settlement. That's what happened in this case, plain and simple. And the case has been an evolution over the last, 15 years, where certain cases, as a matter of law, are deemed to be willful. When you do that, when you have a waiver, a written express waiver, and then you include those items that have been waived in your lien, what are you going to determine? Here, the stock answer from Sigley was this: you owe us the money, but if you don't, it was an honest mistake. No explanation.
All right, counsel, take the point. We'll hear more from you on rebuttal. Thank you.
Good afternoon. John Sparling of Cullen and Dyckman for Consigli. I don't want to spend too much time on this breach of contract or willful lien thing, but I'll address it quickly. The case he's talking about, Casella, was an insurance contract to repair a property that was damaged, and that property, the entire contract was a gross contract, right? Absolutely, you couldn't bill for anything else, and they went ahead and billed way more than that, and that was the subject of the lien. The cases that he's talking about on the willfulness of the lien, the testimony in the record is very clear. You have to do the liens very quickly, or they're waived. He's conceding that a lot of the lien is proper.
Address the gross negligence and negligence.
Yeah, your cross appeal.
Absolutely. This is just another example of a case where a sophisticated commercial builder is trying to get around the waiver of a consequential damages clause. And you need to dismiss
Is there anything
these.
pled that's outside of, I had this obligation under the contract and I didn't perform it?
No, absolutely not, Your Honor.
Judge Billings found it was like I don't know, she didn't use the term act of God, but there was an extraordinary event when the second water incursion. And somehow that takes it out of the contract. Was that correct?
That's what they're claiming, but absolutely, there's no.
That's so narrow, right? It's only in a situation where the public at large, like a fire would happen. A regular flood, even in a building, doesn't go under that
Not
small.
a fire alarm, it's
right?
not a sprinkler system.
Right.
There isn't a
Where there could be
single case.
catastrophic public burning down. That's not
looked-
this, right?
We've looked hard, and we can't find a single case where a temporary water system that is never going to be part for human occupancy or use has been found to fit that very narrow.
Basically only fire hazards, right? Because fire can go really fast and go through a building or 10 buildings really quickly, right?
But counsel used the word extort, and I think that is inappropriate in all instances. But here, there's actually been a settlement of $12.5 million, $9.5 million. There were two appeals from the decision of Justice Billings. One you've already determined. The settlement agreement is in the record, and negligence of consigli is completely removed from that, except if it's carved out. And the only thing they carved out, if we look in the record, I can give you the citation. It's in the record of the first appeal that's been decided. The only thing that's carved out is gross negligence, which doesn't apply, and the breach of contract claim, which the remedies are completely covered by everything in the contract. And those are compliance with the code, precautions to protect property, damage to property remedy. The owner was to purchase property coverage. There's a waiver of subrogation clause. That's how they settled, got $3 million in their settlement. And they got $9.5 million going after the independent subcontractors. And consigli is released in that settlement agreement. And the waiver of consequential damages clause is very clear against each other for consequential damages arising out of or relating to this contract. There's nothing left here. Everything is a consequential damage claim that's covered by the contract, and And that's why, and I mean, it's a standard AIA contract between sophisticated parties, and as you mentioned, Your Honor, there's no specific case that's ever found a temporary water system. So I'm going to hold my time for reply.
Thank you, counsel.
I'd like to address Your Honor's questions on the gross negligence. On August 9th, 2016, the same event occurred. It happened in the morning while people were working. The flood went 2 floors down from the 25th to the 23rd, actually 3 then, went down. But because the workers were there, they were able to shut off the water and there wasn't any damage. 2 months later, the same exact event occurs in the middle of the night.
It's only, is it the same though? The first one was like someone drilled a hole through the ceiling.
That's another event, Your Honor.
Oh, I'm sorry, mistake.
That's in July.
Okay,
That was,
pardon me.
they left a hole in the roof
Right.
in Sigley for 2 days without doing anything.
That claim has been settled. I'm
That
sorry.
was
Go ahead.
settled.
So
Continue.
how does that show a catastrophic consequence to the public?
Well, you have.
That's all, you have to show that.
Well-
Get out of the general.
That construction site is occupied by city inspectors, vendors, brokers, a
That's
ton of people.
catastrophic. The fact that they stopped the water, it was broken, it was stopped. Have you ever, are there any cases at all not dealing with huge fire hazards that have fit into that catastrophic to the public
Yes, Your
exception?
Honor. We, in this case,
Which
one of the.
Which one says that a
I
leaking water that flooded 1 or 2 floors would amount?
Flooded 28 floors, Your Honor. There were tens of millions in dollars of damages.
No, that's exactly what a breach of contract claim is for. So you get your damages. You're seeking tort damages, which are different.
This was an event that should never have happened because they used a non-code compliant temporary water system. Because had they put the drain pipe like they're supposed to pursuant to the code, nothing would have ever happened. That's simply, they were requesting a change order initially. We refused the change order because it was already in the contract. We had already paid for it once. We didn't want to pay for it again. They allowed this to happen twice.
Thank you, counsel. You have made that point. Thank you.
So there was a first flood, which was more limited in August, 2 months before. And guess how that got resolved? It got
With
resolved.
insurance payments, I'm sure.
No, it got resolved by the contract.
Right.
Exactly. The exact same scenario. They made a claim under the contract. We repaired it. It was fixed, all contract, no like claim of tort. The code sections about this temporary water system, it doesn't apply. They conveniently left out the beginning part that deals with human occupancy and habitation. Those code sections don't apply here at all. They didn't design a system. If they had wanted to design a system, then they could have. There was no drawings, no specifications about this temporary water system. And so this falls within all the other cases that we've talked about, that this is just an attempt to get around the breach of contract claim, which is covered by the waiver of consequential damages clause. So we would ask that you please dismiss the negligence to the extent that it even exists after the settlement and the gross negligence claims.
Thank you, counsel. Thank you both. Kshatriya versus Office of Chief Medical Examiner.
Good afternoon. I'm Annette Hassapidis, appearing for the appellants in this case. Respectfully, the court erred in dismissing the petition. I read all the decisions pertaining to parties contesting a medical examiner's cause of death determinations. Not that many, not that many. None of them included a proffer by the petitioner of expert opinion evidence addressing the findings at the crime scene, at the scene at this point. This is the first case to do so.
Do you dispute that Dr. Samuel and Pasquale Sykes looked at the evidence that was given to them? The experts of your clients?
They did not consider all of the evidence, and it's Dr. Pasquale Stiles was the physician who responded to the petition. The earlier ME who had performed the autopsy was not the ME who provided the affirmation. The standard of review requires that the decision.
The reason I'm asking, counsel, is that if they consider it, if ACME considered the evidence and weighed it, because of the standard of review in this case, don't we have to credit that and find that it was not arbitrary and capricious for them to find what they found?
Well, you do, Your Honor, but that didn't occur here. In this case, Dr. Ross proffered several opinions, and I'll focus just on the opinions concerning the bloodstain evidence. Dr. Pasquale Stiles addressed the bloodstain evidence at page 94 of the record, and in sentences addressing 4th and 7th, essentially Pasquale Stiles says that all of this bloodstain evidence, the cast off on the frame of the closet, the blood on the shoes, and the blood on the ligature, all came from bloody purge from the decedent's nostrils. Okay? The problem with that is that the investigator's report doesn't say anything about that. And to the contrary, if you look at page 290 of the record, where they address examination of the body.
Counsel, let me just say, yes, sure, there are two disagreeing opinions about what happened here. Have you ever found a case where we have said that because there is a differing opinion, that the opinion of the person who's charged with ACME is arbitrary and capricious?
No, Your Honor, but that didn't
Yes,
happen
that's
here.
exactly what I'm saying
But
to
it did
you.
not-
You would have to show that we agree. There are two different experts that come up with two different views of it. That you got to do more than that to show arbitrary and
I
capricious.
believe we did. Because
What did you show more than
Dr.
that?
Pasquale Stiles' opinion is not based on the evidence. There is no evidence that there was fresh blood at the time that the decedent was allegedly discovered. At page 290 of the record, there's references only to dried blood. In fact, it is, there's dried blood, excuse me, there's dried blood on the
but
frame.
that's one little piece. But
no,
like, look, there is evidence there to support the medical examiner's view. You can't deny that.
I can, Your Honor.
You're saying there's no evidence. The
I
fact
am
of the choking around the neck and all of
No,
and
I
second.
apologize.
I know. I'm saying that you're saying there is zero evidence that the medical examiner could have relied upon to come to this conclusion.
With respect to the blood evidence.
I'm
yes,
not talking
because-
about the blood evidence.
Well,
I'm talking about the finding of suicide. Is there nothing in the record? You're saying there's nothing in the record that would have allowed the medical examiner to find a suicide?
Given that the medical examiner stopped where they did, they had a conclusion of suicide. The point here is that they ignored the other evidence. Dr. Pasquale Stiles could not conclude that the blood spatter everywhere in this apartment, apparently, came from bloody purge from her nose because the investigator's report at page 290 says that the blood was dried. It could not have happened that way. The blood stain on the ligature, surrounding the entire ligature, if the court looks at page 129...
No, we're not going to, we agree. I mean, even if we agree that there are differing opinions, the question is, was it arbitrary and capricious to come to the conclusion?
Yes,
that
it was.
Why?
Because it was not based on evidence in the record. Dr. Pasquale
You're
Stiles...
saying there was no evidence in the record from which the medical examiner could have found suicide.
That she
Even
could have
if there
found
was
it-
other evidence that didn't support that theory.
There was no evidence to support a conclusion that the blood stain patterns and the blood on the ligature...
I'm asking you a broader question.
If I may then,
The broader question I'm asking you is there no evidence in the record from which the medical examiner could have found suicide, even though other experts made a different, I mean, this is every medical malpractice case. This is every negligence case. Yes, experts come to different conclusions, but for it to be arbitrary and capricious, there has to be nothing there.
it is arbitrary and capricious when the evidence at the scene contradicts a conclusion of suicide. The bloodstain patterns could not have been made at the time that she was cut down. The rigor mortis conclusion by Dr. Ross was not addressed by Pasquale Stiles. Dr. Ross said that assuming that she had been hanging before she was discovered, her legs would have been straight, her arms would not have been bent. In the photographs, rigor mortis was broken. That was not disputed, yet her arm and her legs were bent. Not possible. Dr. Ross said that was evidence of repositioning far earlier than when 911 was called. The determination, the conclusion was apparently drawn of suicide also because of alcohol and other materials in the apartment. However, the toxicology results were negative. So that negated this rabbit hole that everyone went down to presume it's suicide. You see someone unfortunately hanging and you conclude suicide and you don't look at anything else. The other thing we had...
Counsel, you have to address that one on rebuttal. Thank you.
Thank you, Your Honor.
May it please the court, Jeremy Schwader for the respondents. The question is whether it was rational for Office of Chief Medical...
But you heard what your opponent said, that swaths of evidence were ignored concerning blood on the ligature, things that were not grappled with by ACME. And so would that lead to some inference of arbitrary and capriciousness?
Absolutely not. First of all, they were addressed and they were explained. But the key question for this court, and I'll explain why they were explained, but the key question for this court is whether the decision by ACME not to change its manner of death determination nearly 3 years afterwards when this information was provided, which was no new information, was that rational. And it has to be found rational based on the standard of review if there's any evidentiary support for it. So what we have here is, and you can have different, you can argue, if there's arguable support for a different determination, fine. But if there's any rational...
Well, that's what I want to ask you. What's the rational evidence that you are pointing to?
I'll go through it. No, this is all in the record. No evidence of any struggle. No evidence in the toxicology report that she was drugged to prevent some sort of struggle. Substantial evidence.
A rope around her neck when she was, or what do you call it? Marks around her neck indicating hanging.
Indicating the hanging.
Right.
No evidence of a struggle. The substantial evidence in the record showing that she had severe trauma in her life that I don't really want to go through in open court, but it is in the record. It has to do with her family. She has...
Counsel, you're saying that that provides a rational basis even if OCME didn't specifically contest the blood splatter or the blood on the ligature, or that's enough, even if you didn't have a precise answer to everything that their experts found?
Even if you didn't, but OCME did respond.
Well, I understand you're saying that they did, but you're saying even if they didn't,
absolutely,
it's enough on what they found.
Because all you're talking about is, at this point, nearly 3 years later, was it arbitrary and capricious for them not to change the determination that much later based on the arguments that they had received from petitioners, not any new evidence? So there's a suicide note. There is a text message to the boyfriend, ex-boyfriend, 6 days before she dies, that it's a suicide about poem. This is all in the record. I mean, a poem about suicide, excuse me, all in the record. I can go on. Multiple interviews of the ex-boyfriend by the NYPD, which brought no suspicion to them. Interviews with the neighbors. A neighbor who was right next door could hear things that were in the apartment typically, was there all weekend, and heard absolutely no sign of a struggle. All these things are relevant to their determination, and the administrative code allows them to consider these things as part of their determination. So there is ample evidence in the record that supports their determination. And I would say that my friend, in their letter and now, are pretty much ignoring all of this evidence, which the record shows OCME relied on when it made this determination not to change its determination 3 years later. If there's no further questions, I'll rest on the papers.
Thank you, counsel.
Thank you.
Very briefly, the OCME relied on its assumption that there was fresh blood at the time of the recovery of the body 2 days after she had last seen the boyfriend. There is no evidence in the record to support that at all. It's contradicted by page 290 of the record.
I'm sorry, so if we agree with you on that point,
Yes.
is that error of such a magnitude that it would render the determination arbitrary and capricious?
I would submit to you, Your Honor, that's a qualitative analysis, right? But when you look at the evidence of rigor mortis, you look at the fact that the boyfriend lied. He told the police that the 911 operator told him to cut her down. The 911 tape showed that he was never told of such a thing. There was a conclusion that drugs were used when her tox screen came back negative. There was a
I don't think that there was a conclusion that she used drugs to kill herself. Are you saying
in advance
that?
of the apartment had the drugs. This is evidence of staging. You also, counsel repeatedly refers to the fact that
again-
this came up 3 years after the fact. I'm sorry, Your Honor.
I just want to say, but are you not? How about all the evidence or how about the evidence going the other way? You're completely ignoring all that and saying it doesn't exist. And even if it's a contest, that's not arbitrary and capricious. Even if you could say it's an issue of fact for a jury, that's not arbitrary and capricious.
Your Honor, this is about science that was not disputed by the ME's office. We were at least entitled to a hearing and to discovery and not simply relying on the ipse dixit of the ME's office. This court in Giselli said just that. The retirement system took a position in interpreting a statute, and they said, that's been our practice. And this court said, it's not about your ipse dixit. Just because the ME's office says it's suicide doesn't mean that it's not arbitrary and capricious. You have scientific evidence, the rigor mortis, the claim of fresh blood when there was no fresh blood at the scene. How can that be sustained as not being arbitrary and capricious when it is contradicted by the very evidence in the record? And with respect to the note, and I see my time is up, I would just like to conclude.
Complete the thought, counsel.
With respect to the note was conveniently sticking out of a book in the apartment. It came from another book that was nowhere found. There was a bathrobe belt and no bathrobe. There were so many disconnected pieces here that warranted further review. There was unrebutted evidence of the cast-off patterns and the bloodstains being inconsistent with suicide. There were contusions on the body that showed that they were consistent with assault.
You unpacked that very well in your brief, counsel. Thank you.
Thank you.
Thank you both.